Hey everybody, welcome back to Law, Politics, and Society. I hope you had a great spring break and that you're ready to dive back into some new material. Just a reminder that the test opens up on Friday and will be open until the end of the day on Monday. So if you don't have extra time, you will have to make sure that you start the test before 10 p.m. on Monday in order to make sure that you don't lose any points for lateness. Okay, with that out of the way, let's get started. So this week we're talking about criminal procedure and its purpose. And so criminal procedure sets forth the appropriate lines of behavior for state agents. So this includes police officers, sheriffs, anybody that acts as an agent of the state that's going to come into contact with individuals. This can be federally too, if we're thinking about ICE agents, for example, or individuals from the ATF, alcohol, firearms, and alcohol, tobacco, and firearms. So this criminal procedure setup is derived from the Due Process Clause of the Fifth Amendment, as well as the 14th Amendment, which are tremendously important legal concepts because they set the pendulum between the due process and the crime control model. This really attempts to balance those differing goals. And it's difficult because the more procedure restrictions you put on the police, the more due process you get. But the more you don't restrict the police, the more crime control you're going to get. So you really have to think about how that line is going to be drawn. And due process has become an incredibly important cornerstone of law to ensure that we're not wrongfully convicting innocent people, and to ensure that the burden of proof is still on the prosecution and the state to prove their case. So the sources of our procedural criminal law primarily comes from the Bill of Rights within the US Constitution. So the ones that we're going to focus most specifically on are the 4th, 5th, and 6th Amendments. But some of the other amendments, you could argue, play a role as well. The 14th Amendment is also important. The state constitution regulates some behavior in the individual states. Federal and state statutes are important, but what we see change the law most is Supreme Court decisions. And that is partially because they're interpreting the Bill of Rights and those privacy protections and liberty protections, but also because those affect all of the states. So you're not relying on individual states to protect liberty, but you can get a big decision with a lot of protections in one court case. So you will remember a few chapters ago that search and seizure law is primarily governed by the 4th Amendment. And there are two main clauses within that 4th Amendment. There's the warrant clause and there's the reasonableness clause. So the warrant clause says that a warrant must be obtained based on probable cause. So remember that all warrantless searches are going to be presumed unreasonable unless there's some specific circumstances. So to get that warrant, you have to describe the person, place, or thing with particularity that you wish to search. So this is to avoid fishing expeditions where you get to guess that there might be something illegal somewhere and you want to go see what it is. You have to describe what you want to search with very high degrees of specificity. The reasonableness clause allows searches without warrants in very narrow circumstances when you can demonstrate both probable cause and exigent circumstances. So there's some great threat to an individual's life or liberty or property that makes it unreasonable to go get a warrant. So for example, if you are pursuing a felon and you've seen them commit the felony, it's unreasonable to have to go away from that pursuit, go get a judge to sign a warrant, and then come back and hope your suspect is going to be there. So you have to justify exigent circumstances. And there are examples of this the court has spelled out, but they tend to work on a case-by-case basis. So in the grand scheme of things, probable cause is a fairly new concept, and it was first defined in 1949 in Bringier versus the United States. And that case held that probable cause exists when the facts and circumstances that the officers have and that they gained from reasonably trustworthy information are sufficient enough to convince themselves and or a man of reasonable caution in the belief that an offense has been committed. So that is a bunch of legal jumble for would a reasonable person agree with the officer, so that's an objective test, that there is reason to believe this item would exist or that this individual committed this offense. So the officers have to meet an objective test standard. It's not enough that they might think or have a hunch. They have to base it on a reasonable person standard. And this was expanded in Illinois v. Gates in 1983, where the court said that this is a fluid concept. It can ebb and flow to fulfill a variety of specific circumstances, and it doesn't have to require absolute certainty or even a great likelihood. It needs a more likely than not scenario, so 51% standard, which is similar to the preponderance of the evidence standard in civil trials, and we'll talk about civil law a little bit later. But basically, is it more likely than not that that person has it, or that person did the thing that we think? So this is a much lower burden than you would need to obtain a criminal conviction. This is just the more likely than not standard for whether or not you can conduct your search. Now, many people think of the Fourth Amendment as explicitly focusing on search, but it also prohibits unreasonable seizures. So what is a seizure? Well, it's the exercise of dominion or control by police or state agents over a person or an item. So it's a broader term than arrest because it can encompass the control of items and property, but it also includes the seizure of people. And a seizure of a person is called a detention. So detention occurs when a reasonable person, again, that objective test standard, viewing the particular police conduct as a whole and within that setting, would conclude that the police had restrained their liberty so that they are not free to leave. So we understand a detention is, would a reasonable person in the same circumstances, in the same situation, assume that they are not free to leave? And if that is the case, then the individual has been detained and is under detention. And so that's the standard that you have to make sure, and the police have to make sure they don't violate, because an unreasonable detention is not allowed under the Fourth Amendment. But there are going to be times when officers can make arrests and can detain individuals. So when is that? Well, officers can get search warrants, but they can also get arrest warrants. And if they have a warrant signed off by a judge, they can certainly make an arrest. An officer can also arrest if they have probable cause. So if they've seen something happening, or if, again, balance of probabilities, it's more likely than not that the individual engaged in that behavior, that illegal conduct. If misdemeanors or felonies occur in the presence of an officer outside of a private dwelling, so not within a home, but if the police witness an offense, they can typically make an arrest then and there. But police cannot make warrantless arrests in a private dwelling unless there are exigent circumstances or they have consent to enter. So we're going to talk about consent searches a little bit later, but generally you should never consent to the police searching, ever, ever, ever. And you will have seen a video that a fabulous defense lawyer and professor gave that explains why you never want to talk to the police and you never want to give consent searches. But It's something that has been held over from the old common law in England as to the castle doctrine. So your home is your castle. You have a right not to be threatened or harassed there. So if you watch shows like Law and Order or Law and Order SVU, they will regularly ask people to step outside onto their front step before they make an arrest. And so this is why. So how can the police go about arresting you? Well, the law says that they can use whatever force is reasonable under the circumstances. So if you do not pose a threat, if you are not being aggressive or hostile to the police in any way, if you comply with their requests to let them see your hands, to refrain from moving, they can use very little force. But if you begin to resist, if you have a knife or a gun, they can use as much force as necessary, all the way up to deadly force, if it is deemed necessary to protect life. So there have been a number of instances in recent years where police have come under scrutiny for their use of deadly force and perhaps relying too frequently on deadly force. But it is a principle whereby they are allowed to do so if they can demonstrate that it was necessary to protect life. If it was not necessary, if they use too much force, they can be subject to internal reviews, to citizen reviews, and even prosecution if they engage in the use of unjustified force. Police, when they're coming to a dwelling to arrest, must knock and announce. So they have to tell you that they're there, they have to announce their presence and their purpose, and they have to give the occupant a reasonable amount of time to open the door. Generally. Now, this is not always true, because if escape is likely, or if they have reason to believe that officers will be injured, or that evidence will be destroyed, they can get what are called no-knock warrants. So this is frequently used in terrorism investigations and investigations where they're seizing drugs, for example, because you don't want to give the potential criminal notice so that they can dispose of all of the evidence that you're going to arrest them for, or potentially set off, a detonating device. So if they have reasonable belief that there may be a reason why they would be in danger, they can ignore that rule. But generally, if it's a fairly low-level crime, or even if it's a severe crime, but like a homicide, but the person is not likely to be a danger, they must knock and announce. So if the police come up to you on the street and ask you a few questions, that does not amount to an arrest or a seizure. Police officers will do this frequently if they're in the area. Just ask, hey, how's it going? Do you mind if I ask you a few questions? That is not a detention. It's not a seizure. It's not an arrest. And the reason is because you have the absolute right to ignore them or walk away. And that behavior cannot constitute probable cause. They can't say, well, you didn't want to talk to me, so now I get to arrest you. Absolutely not. And people often don't realize that they have the right to just walk away. You don't want to talk? Don't talk. You're late to class? Go to class. You don't have any reason to stay and talk. But there are seizures that can occur that the court says are tantamount to arrests. And these require more than mere suspicion, but not to the level of probable cause. They are classified as seizures, but they're not quite full arrests either. And the two types we're going to talk about are traffic stops and stop and frisks that occur typically on the street. So stop and frisk laws were really clarified in Terry v. Ohio, which is one of the most famous cases for the Fourth Amendment. It was decided in 1968, and it says that in order to conduct a stop and frisk, there must be reasonable suspicion based on experience of the officer, but they set a less demanding standard than the probable cause standard. And this is sometimes referred to as a Terry stop or an investigative detention because it's not an arrest, but it is a form of seizure. So the Fourth Amendment does apply, um, and the search can't be a full search. It just you need reasonable suspicion, but you can't, search every crevice of a person on the street corner. So the stop, according to the Terry rules, must be temporary and no longer than necessary under the circumstances. So it can't be, more than minutes. And the frisk can only be if the stop does not allay the officer's fears. So if the individual has been behaving erratically or acting in a manner that seems suspicious to the police officer, they can do a pat down of the outer clothing. Officers may not manipulate items. They can't start just touching everything on you to see, oh, well, if I turn that this way, this feels like a bag of weed. But if I turn it that way, it feels like it might be a gun. No, they don't get to just start touching you everywhere and feeling out items. They can do a pat down to make sure that you're not carrying a concealed weapon. This is called the plain feel doctrine. But if it's not something else, if it's soft, if it doesn't feel like a gun or a weapon, they cannot just start seizing things and figuring out what all the things that you have on them. So this is really supposed to be for officers' safety, although it has been extrapolated to be more than that. And this is why in New York City, their stop and frisk program was ruled unconstitutional, because you had officers using racial stereotypes and relying on essentially myths instead of reasonable experience and evidence to stop a disproportionate number of Black and Hispanic individuals. So this is the part of the presentation where if I was teaching this in person, I would pause the lecture and have you listen to Jay-Z's 99 Problems. So I encourage you to go listen to that now and to decide whether or not you think that the vehicle stop depicted by Jay-Z is appropriate or not appropriate based on the material you're going to learn. I absolutely love that song. So see if what he says matches what I'm going to say. So a seizure occurs whenever a vehicle is stopped. The police have to have reasonable suspicion to stop a vehicle, except if there are certain roadblocks. So if they have closed an area to traffic, or they're engaging in random sobriety checks, that is completely acceptable. They're allowed to do that. But otherwise, they have to have at least reasonable suspicion. The police absolutely are authorized to ask you to get out of the car, even for a minor traffic violation like a broken taillight or speeding. They can absolutely ask you to get out of the car, and they can ask for other documentation such as insurance, your driver's license, other sort of identification about the car and the occupants. If you refuse to identify yourself, you can be arrested in this situation. So traffic stops are very different. You must provide some form of identification. And what will typically happen then is there will be an officer asking you whether or not he can search the rest of your car. This is called a consent search, and you have the right to say no. You can say, I'm not interested in having you search the car. And if you say no, the police cannot use that no against them. And if you say no and the police don't have any other reason to search the car, then they can't, and they can't continue the seizure. If, for example, they see something that's in plain view on the passenger seat, for example, they see an open container, they don't have to get your permission to take that and to seize it. That's within their plain view. They know that you have it, and they can ask you to do a breathalyzer test or engage in sobriety field tests without requiring your consent. But if there's nothing on the passenger seat or in plain view that demonstrates a violation of a law, they will let you go. Okay, so moving on from seizures to searches, the big protection that was created under the Fourth Amendment is in Cates v. United States in 1967, where the court created the Reasonable Expectation of Privacy Framework, or REP. The Fourth Amendment reasonable expectation of privacy applies only to very specific places. These places are when the subject of the search has a subjective expectation of privacy, and society must view that expectation as reasonable. So this is both a subjective and an objective test. So if you have a property interest in something, your purse, your backpack, your car, your house, your computer, your phone, you will have a reasonable expectation of privacy of those things. Where it gets complicated is, what about your garbage, right? If you've thrown it away, have you discarded your property interest? Is that free for the police to then pick up? The courts have said yes, unless it's still within your property line. Then it can be a little tricky. But if it's off of your property line, or it was never in your property to begin with, let's say you were sucking on a Coke can and you threw that away, then you're forfeiting your reasonable expectation of privacy. So in order to determine that expectation, it's always going to be that two-step test. Subject of the search has to have subjective expectation of privacy, and society has to believe that that is reasonable under the circumstances. So like I said before, typically police need to get a search warrant in order to search somewhere, but there are exceptions. So let's go through those exceptions. The first exception is search incident to arrest. So if police have an arrest warrant, or if they saw you committing a misdemeanor or a felony, when they put you in handcuffs, they can do a search. And the guidelines or outlines for this was created in Chimel v. California in 1969. And this applies if the police decide to arrest. So they've decided, yes, they're going to arrest you. They can search you at that time to ensure their safety, to make sure that they are not in any danger. So this can include anywhere on an individual person, as well as what is called the lunge area. What could they get if they lunged? So sharp objects, anything that's heavy can be pushed away or cleared away so that police are not in danger. But the police can't search, other rooms in the house when they arrest you. They can only search what's in your immediate presence within your ability to lunge. Consent searches are how 95% of searches happen. It's because people say sure, or fine, or okay. They have to be voluntary and intelligent. So the police have to have asked you without trickery, without any games, without lies, whether or not they can come in and search your room or your house or your car. It must be limited to both time and area. So, Mr. Smith, are you okay if I search your kitchen right now? Sure, right? It doesn't give the police permission to search it forever or tomorrow or next week. It just means that you are consenting to that at the moment, right? Similarly, Miss Jones, is it okay if I take a look in your backpack? The assumption is that would be right now, but you are absolutely allowed to say no. And one of the most interesting things about this is the police are not required to inform you that you can say no. So this is something that I always focus a lot on with my students. You can say no. The police will never tell you that you can say no, but you can, and it cannot be used against you. You can also withdraw your consent at any time. So initially you might have thought, yeah, this won't take too long, this is fine, no problem. But after they've been searching for 10 minutes and you have to get to class or you have to get to work, you can say, no, you know what, I actually withdraw my consent for the search to continue, and the police have to stop. The third is that valid consent can only be obtained from the person who has the authority to do so. So this is the resident or the owner of a home or a car. And so this means that you can't have your roommate giving consent for your bedroom. That is not appropriate. A roommate or co-occupants can give permission for a common area, so areas you both share and both use, but co-occupants can't give permission for the other occupant's exclusive space, particularly if they're not home. And one of the important things in consent also is that a no will always override a yes. So if you have two co-occupants, One says no, one says yes. The no will override a yes in consent searches. What about cars? Well, there are exceptions to the search warrant requirement for cars that are on the road, not in garages or on your property. And this was set out in Carroll v. United States in 1925. And the argument here was that cars are movable, obviously, and this lessened the expectation of privacy for when they are in public spaces using public property, like roads, for example. And so if the police want to search your vehicle without a warrant, they can establish that the vehicle is mobile, which if you're driving anywhere is already met. But again, doesn't apply to garages or impound lots or your property. And they have to establish probable cause. So if there's no warrant, they need to establish probable cause. Search incident to arrest for vehicles after the arrestee is secured is not permitted unless it's for evidence relating to that arrest. So if you're arresting someone for driving without a license, you ask them if they have a license, they say no. You don't get to go looking through their glove box and their trunk and their back seat for, whatever you feel like. But you can, if it's a driving while impaired arrest, you can look and see, do I see bottles anywhere? Do I see empty beer cans? Is there anything that smells like alcohol? That would be a completely legitimate vehicle search without a warrant. Inventory searches, so a search of the entire car, are limited to protection of property of the arrestee. So if they're going to impound your vehicle because they're arresting you, they are allowed to do a warrantless inventory search, so long as it's routine and it's not done as a pretext to find more charges against you. That would be unconstitutional. They can also surveil and monitor vehicles on open roads. So they can have traffic cameras and pull footage to see who's been driving where and when, because your vehicle is moving in public space. So they cannot do that. Again, they cannot set up surveillance without a warrant on your garage or put a tracer on your vehicle without a warrant to see where you live. That would not be acceptable. Because this constitutes a trespass. You have to have a search warrant if you're going to be installing anything that tracks a vehicle when it is not on public property. So impound searches, yes, are fine. Inventory searches, as long as they're done legitimately and not as a pretext for contraband searches. And warrantless searches of impounded vehicles are okay, even if the driver hasn't been arrested, if there has been some demonstrable infringement. So I mentioned the plain view exception a little bit earlier. It's not actually an exception so much as it is an instance when search warrant requirements don't apply. So this was set out in Harris v. United States in 1968. And the court decided that objects are subject to seizure if they're in plain view of the officer who has a legal right to be in the position to see them. So if there's an officer conducting a traffic stop based on a legitimate circumstance, based on probable cause, and they can clearly see that there's an open liquor bottle on the passenger side, that is absolutely legitimate. That is in plain view. They haven't had to dig for it. They haven't had to get your consent to see it. They can just see it. The item must be immediately apparent as contraband. So if they see a Slurpee cup, for example, that wouldn't be necessarily apparent as contraband, but they can use tools to aid in their observation. So they can use a flashlight, for example, and see, oh, look, under that passenger seat, there's an empty beer can. They can see binoculars if necessary. They're allowed to use tools. But it does not apply to what they smell or what they touch. It's just what they see. So they can't take advantage of this as just a fishing expedition. It has to be immediately apparent that the item observed is contraband, evidence of the crime, or fruit of the crime. They cannot move items. They cannot manipulate them and feel around and see, oh, maybe that, no. It's just what you see is what you get. As I mentioned before, one of the exceptions to Seizure is abandoned property if you've thrown something away, but that's also true of searches. If you've abandoned property, then that property is no longer protected under the Fourth Amendment. Now, what constitutes abandoned depends on where the property was abandoned and the intent of the person who's getting rid of it. So when was it abandoned? When was it thrown away? Um, you know, if a textbook is in the trash in a classroom, that's clearly, demonstrable that it's going to be thrown out. Items thrown in the trash on private property are not considered abandoned until it's outside the property line. But again, if you throw something away in a garbage can on the street, that's fair game. Other exceptions to the search warrant requirement: special needs of law enforcement. So this sounds really broad, but they're known as administrative searches, and they are a fairly narrow exception. So this can be in cases that are a mixture of criminal investigations and conduct by other public agencies. So this can be searches of students by principals or vice principals. This can be searches of probationers or parolees, where the court has held they can be conducted without a warrant on less than probable cause, because there is a particular set of circumstances that has occurred. Individuals on probation waive Fourth Amendment rights because their parole officers may have to go visit them as needed by law enforcement. And you have less reasonable expectation of privacy in public schools than you do in most other places. Similarly, you don't need to get a search warrant for the TSA to search your airport items because you have a choice. You cannot fly. But if you decide to fly, then you are subject to those types of searches. Similarly, Border Patrol. If you want to drive your car through the border, they have a right to search you. So other agencies, there's also some flexibility. Okay, so as you'll remember, the right to counsel is one of those rights that's specifically enumerated within the Constitution. And it was originally interpreted by the Supreme Court as those who wanted and could afford counsel could not be denied. So if you could pay for it privately, then you had a right to it. But this changed during the Scottsboro Boys case in the 1930s, in the case of Powell v. Alabama. So the court held that due process requires the appointment of an attorney at the government's expense for indigent or poor defendants facing capital charges. So this was the first time that an individual would be entitled to an attorney if they couldn't pay for one, but only if you were facing the death penalty. So that was the beginning of a right to counsel for everybody, even if they couldn't afford it, but only if they were facing capital charges. Johnson v. Zerbst in 1938, 6 years later, expanded this to all federal felony cases. So it didn't apply to the states. It only applied to federal defendants facing felony cases or individuals at the states who were facing capital charges. Gideon v. Wainwright in 1963 was really a landmark case because it made it applicable to all felony cases in every state. So that was a huge incorporation of the Sixth Amendment. And in Hamlin in 1972, we extended it again to any indigent defendant facing incarceration for a felony or a misdemeanor, so it's getting even broader, when there is a possible sentence of more than 6 months of incarceration. So not 6 months of probation or 6 months of community service if the individual is facing more than 6 months of incarceration. Now you might be thinking, well, wait a minute, I know about the right to counsel even if I'm poor because of the Miranda warnings. Yes, you do, but that actually started for a different protection. It started from the Fifth Amendment protection against self-incrimination. So the Constitution says that you have a right to not incriminate yourself. You can choose to. So again, if you choose to speak, if you choose to incriminate yourself, that is up to you. And that was held in Escondido versus Illinois, that if you speak and it's voluntary, absolutely, that is admissible. In Miranda v. Arizona, 2 years later, what we found was that the suspect must be informed of their right to counsel and to remain silent before the custodial interrogation takes place. And that was absolutely huge. So what we have here is that unless a Miranda warning had been given to the suspect, anything they later say cannot be used against them at trial. So the Miranda warning set out what the police should say to all individuals who are going to be subject to custodial interrogations. And this is what you will be familiar with, right? You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided to you, right? This all sounds familiar. But if you do not do that before a custodial interview, everything after that is going to be inadmissible. So here are those Miranda rights that you will be very familiar with. And the timing of the Miranda warnings are crucial. So it has to happen before an interrogation, which is typically just after arrest. But it also can be when there are restraints on the freedom of movement. So if there hasn't been a formal arrest, but it's clear that the defendant or the individual in for an interview, shall we say, is not free to leave, you have to Mirandize. So we call this the free to leave test. Would the individual have believed that they were free to leave? And if they have asked to leave and were told no, they need to have been Mirandized. Police are allowed to ask questions that can incriminate, right? And this is called an interview or interrogation. And in circumstances which police, through their actions, create the functional equivalent of an interrogation, they also have to Mirandize. So when they engage in any activity that they should have known is reasonably likely to invoke an incriminating response from the suspect, they have to Mirandize. So this is the base level of, do you want whatever the person says to you to be admissible in court? You probably do if you're a police officer. Mirandize them. Equally important, there is a lot of times when the Miranda warning is not required. Routine traffic stops are not an interrogation. You're not under arrest. No Miranda needed. Same with sobriety checkpoints. Same if the officers are having a conversation between themselves and you interject, you are jumping into their conversation, not the other way around. No Miranda needed. If you walk up to, a police officer walks up to you and you all of a sudden volunteer, okay, I did it. No, the police didn't have to Mirandize you. They didn't talk to you at all. They weren't prompting you. You volunteered. No Miranda needed. Routine questioning of persons at a crime scene. No Miranda needed. They're just asking for information. So that's not an interrogation. Individuals are free to leave. Clarifying questions do not need any sort of Miranda. And questions that are part of a stop and frisk. So if the police come up to you and say, do you have a weapon on you? They don't have to first give you a Miranda warning. And if there is a threat to public safety. Now, the public safety exemption has changed a lot over the years, but typically what it means is that if there is a ticking clock and there is a great danger to the public, a bomb's going to go off in New York City in 5 minutes. If they can't get you to talk, then perhaps they will not have to Mirandize you. But generally, they have to, unless they can demonstrate that there's that grave a threat. So even in the case of the Boston bombings and the Tsarnaev brothers, they were Mirandized. So it's going to be a pretty high threshold. Okay, so after the police have read you your Miranda rights, what happens? Well, it depends on if you invoke them or not. So after that whole spiel, if you say, I wish to exercise my right to remain silent, then the police cannot question you anymore until you start talking to them. And this includes other crimes unrelated to the current offense. So if you say, I am invoking my right to remain silent, they cannot keep questioning you. They cannot ask you about other offenses. The questioning has to stop. But if you start talking to them, that could potentially constitute as waiver, where you're waiving your rights. The police don't have to let the suspect know that a lawyer is waiting if it's been acquired by a family member. If you have called your own lawyer and your lawyer is waiting, then questioning has to stop. But if you're talking to the police and a lawyer arrives and they've been retained by your parents, the police don't have to tell you that. They can wait for you to actually say, you know what, I'd like to get a lawyer. And then, okay, the lawyer's here. If the police are posing as an inmate, they obviously don't have to Mirandize you. That would give it away fairly quickly, because no other inmate would ever Mirandize you. So the jail cell where they're posing as an inmate is not coercive. An individual would not believe that they're interacting with a state agent, so no Miranda required. Other extensions and applications of Miranda. If you start talking after you've been arrested, completely unwarned, they can remedy any confusion if they give the proper Miranda warnings and obtain a waiver of your rights and then re-obtain the confession. So the police don't have to tell you that the initial question was and conversation and confession was inadmissible. They can just say, hey, I'm going to give you the rundown of your Miranda rights, and then I'm going to get you to write down everything you just said to me. And it'll sound like that's all legitimate, even though everything you would have said previously would have been inadmissible. Illegally obtained confessions may be admitted at trial to impeach a defendant's testimony, but only if you take the stand. So if you choose not to take the stand, then illegally obtained confessions will always be out. They will be inadmissible. But if you take the stand and you lie, or there's some gray area as to whether or not you're telling the truth, then your legally obtained confession will now be admissible. It can only be used to impeach your testimony, however. It can't be used about any other issue. Finally, Miranda rights can be waived. So you can waive your Miranda rights, and you don't have to say, I waive my Miranda rights. It just means that if you knowingly, intelligently, and voluntarily continue speaking or continue writing or continue engaging with the police after they have told you about your rights, that will constitute a waiver. And so long as there's no possible coercion. And we've seen children as young as 13, 14 in the Slender Man cases in Wisconsin waive their Miranda rights. So in Wisconsin, children as young as 12 can waive their Miranda rights, which seems really daunting. In a lot of states, it has to be a lot higher age. And the question can also be whether or not individuals with developmental difficulties or IQ impairments, like Brendan Dassey, for example, would have known that he was waiving his Miranda rights. Those questions can get tricky, but these are where points of law often come up, and we get a clarifying question from the Supreme Court. So that's why the Supreme Court jurisprudence is so helpful with procedural law. So the Confrontation of Witnesses clause in the Sixth Amendment say that any accused person has the right to be confronted with the witnesses against him. This means that the defense has an opportunity to test the credibility of hostile witnesses, which means that the defense will always be allowed to cross-examine any witnesses. It will prevent the use of hearsay statements, which are statements made ex parte or outside of the courtroom. They're prohibited in criminal trials because of the Sixth Amendment protection. And so very important cases on this are the incorporation of the Confrontation Clause in 1965 in Pointer, which is when the Confrontation Clause was obligatory to the states as well as the federal court system. But in Crawford v. Washington in 2004, we got a different interpretation of the Confrontation Clause. So in this case, we had to look at what would happen if witnesses were absent. And the court said that absent witness statements can be admitted if the witness is unavailable or if the defense had prior opportunities to cross-examine that witness. So if somebody has died, for example, their evidence or their testimony, if it's on video, may be admitted even though it happened ex parte, because the unavailability of that individual. Sometimes the defense will had opportunities to cross-examine a witness previously, and then they can bring that individual in. So an unavailable witness means a witness who is demonstrably unavailable or unable to testify in person. So this can be somebody who's dead, somebody who has a marital exception, and sometimes children. So it does not give the right, the Confrontation of Witnesses Clause does not give or guarantee the right to face-to-face confrontation. Children, for example, frequently testify behind a shield or in a different room via video conferencing, because it would be very traumatic for children to have to be in that process. So the courts have changed the standard on this fairly recently. So what happens if the government breaches your constitutional rights, particularly against your right to search and seizure? Well, there's something called the exclusionary rule. And the exclusionary rule is a purely judicially created measure, so it's come by the courts, and it says that any evidence obtained by the government in violation of the Fourth Amendment guarantee against unreasonable searches and seizures is not admissible in a criminal trial for the purposes of proving guilt. So this originated in Weeks v. United States in 1914, and initially this decision only applied to the federal government. And it led to the issue of what was called the silver platter doctrine. And the question here was whether or not evidence was being given to law enforcement agencies through the fruits of illegal activity. Because evidence could still be used by the state police and turned over to the federal law enforcement on a silver platter, because the federal law enforcement officers say, well, we didn't violate any rules, they just handed it to us. And so that was obviously a big problem. And the exclusionary rule got further clarified in Nardone in 1939 when the fruit of the poisonous tree doctrine came down, which said that the whole interrogation, the whole process, the whole investigation could be tainted or poisoned with the admission of illegally obtained evidence. So if you engage in a legal search, which then turns up a gun, which you then show to Jimmy and Jimmy confesses, well, if your illegal search is how you got the gun, and the gun is why Jimmy confessed, the whole thing is going to be out, the gun and the confession. So you have to make sure, this still only applied to the federal government at the time, but they had to make sure that they were doing everything properly as to not taint the rest of their evidence. In Wolf v. Colorado, we finally get the exclusionary rule applied to the states in 1949, but it largely left the enforcement up to the state judiciary and state courts. And that's why there needed to be clarification, which happened in 1961 in Mapp v. Ohio. And this is because the states were not giving adequate remedies for violations committed by the state police. They might not allow the evidence, or sometimes they might, or they might backdoor it in. And the court said, enough, you can't be trusted with this. We're going to lay out the remedy for the exclusionary rule, and you will not be able to backdoor evidence in. So if you are obtaining evidence in violation of the Fourth Amendment, it will be out. But of course, like any good rule, there are always going to be exceptions. So, like we talked about a little bit earlier, legally obtained evidence can still be used in criminal trials for the purpose of impeaching a defendant's testimony. So if somebody lies on the stand, or if somebody does not tell the whole truth about something, then we can bring in previously deemed unadmissible or inadmissible evidence to impeach credibility. And there are really three other early exceptions and two more recent ones. The first is the standing exception. So the standing exception was clarified in Rackus v. Illinois, and it said that in order to claim this Fourth Amendment protection, an individual had to have standing. That is, they had to be directly affected by an issue, by being personally harmed. And so if you were not the person harmed by the violation, you weren't prosecuted, you didn't suffer any sort of consequences, you can't decide you're going to bring an issue for exclusion. So you can't just have Joe off the street saying, hey, I don't think Jimmy should have his evidence. No. You have to have standing. The independent source exception is the biggest one, and this is that inadmissible evidence may become admissible if the knowledge of that evidence is gained from a source entirely independent of this previously tainted source. So if you can demonstrate that you could find out about this evidence without any influence or tainting of the evidence, it can come back in. So let's say you know about a gun that you're not supposed to know about. That gun is inadmissible. And you keep investigating the case, and a new source, completely unconnected to the old source, tells you that Johnny has a gun and this is where it's hidden. Well, then the gun can come back in because you learned about it from an untainted source. The attenuation exception is when illegally obtained evidence can be admissible if there's a less than clear causal connection between the illegal police action and the evidence. So this is when you have a process where perhaps there was a violation, but it's not clear that the evidence was brought through by that violation. So your text gives you the example of Wong Sung and the Supreme Court decision. So basically, if there's a big gap or a big differentiation in circumstances, the attenuation exception might apply if there's a less than clear causal connection. In the U.S. v. Leon in 1984, we got the good faith exception, which is controversial because it just requires the police to demonstrate that they were acting on good faith. So if the police do the right thing, but a magistrate screws up or a judge shouldn't have given them the search warrant, but does, but the police didn't knowingly violate the Fourth Amendment, they just happened based on something else, then usually the evidence will not be excluded. But it depends. There's a case-by-case test for this. Arizona v. Evans is a case where we saw this in 1994, and your text discusses it as well. And then the final exception is the inevitable discovery exception. We use this one in Law and Order a lot. This is from the Nix v. Williams case in 1984. And this is when you can introduce evidence at trial that would have been inadmissible if you can demonstrate you would have eventually discovered it by legitimate legal means anyway. So if you couldn't have that gun, you weren't allowed to know about the gun, you got that gun from an illegal search, but it turns out that later on you would have had enough to get a search warrant to go back and find it anyway, you probably could make the case for inevitable discovery. So, of course, we have exclusionary rules, but like any other rule in the English world, with every rule comes exceptions. So that is Procedural Law 101 in a nutshell. If you go on to law school, you will take a full year-long course on procedural criminal law. So I don't pretend to go over every possible rule and exception, but due process and procedural law are very important legal concepts, and so I hope you enjoyed learning about this week. I'll see you soon.